Welcome to the Texas Conflict Coach radio program. If you've ever experienced or engaged in destructive or unresolved conflict, then you know it leads to broken relationships, distrust, and damaging results. Our program will help you manage and resolve conflict effectively with strategies, valuable resources, and support. Since 2009, our radio program hosted guest experts from around the globe sharing their perspectives, experiences, and expertise while giving you food for thought. If you can't listen live, then download and listen to any of our 300-plus podcasts in our library at texasconflictcoach.com. So sit back, relax, or join the conversation every Tuesday evening, or tweet us at TXConflictCoach.
Good evening. I am your guest host, Tracy Colbreth, and with host Patty Porter, we are continuing our Conflict Resolution Month programming with Dr. Jack Goetz. In tonight's programming, Lowballing the Public, Mediators Serving Without a Binding Ethics Code on 40 Hours of Training, we will be discussing a controversial topic among mediators nationwide with Dr. Goetz, who will chronicle current efforts in Voluntary Mediator Certification underway in California to raise the level of mediator education and training and require a binding ethics code to serve the public. The practice of mediation is largely unregulated throughout the United States. In contrast to more formalized professions such as nursing, social work, law, medicine, or accounting, mediators generally have a fraction of the training, have no required ethics code, and no minimum quality testing. Dr. Goetz has trained hundreds of mediators during the last 7 years through the California State University system. Prior to developing the mediation program, he was the founding dean and president of Concord Law School, the first nationally accredited online law school. Dr. Goetz advocates for a stronger sense of professionalism in the field of mediation and recently co-authored with Dr. Jennifer Kalfsbeek the article Serving the Public, the Case for Formally Professionalizing Court-Connected and Litigated Case Mediation. He currently serves as the co-chair of Southern California Mediation Association Ad Hoc Committee on Voluntary Mediator Certification. We invite listeners to the chat room to post your comments or questions at www.blogtalkradio.com/Texas Conflict Coach. You can also communicate with us through our live Twitter feed using hashtag TCCRadio. I would like to take the time to welcome Jack to the program and also our host, Patty Porter.
Hello, Tracy.
Hi, Patty.
Hi, Tracy.
Hi, Jack. Jack, you have a passion for lifetime learning and engaging and encouraging others to learn. What drives you, in particular, to educate and engage adults in mediation and conflict resolution?
Tracy, that's a great question. I think my own life experience in the legal system as an individual in society and as a business person, despite being the prevailing party in many different disputes, when I reflected back on the experience, what little was left for me didn't outweigh the emotional toll of the litigation and the havoc it caused in my life. And I think all of your listeners know, and many others know, that many disputes, particularly neighbor-to-neighbor or community disputes, where the money is not as significant as the relationships or other things going on in dispute, are just not the right thing for the courts. So, I think part of my passion for this has to do with knowing that alternative dispute resolution and knowing that mediation is a superior mechanism and trying to make that work on a more widespread basis throughout the United States.
Thank you, Jack. I really appreciate you sharing that with us. Can you speak a little bit more to mediation and tell our listeners exactly what mediation is?
Well, mediation is when a third-party neutral, meaning someone who's not biased or prejudiced in one party's favor, facilitates a discussion amongst two different individuals who are in a dispute. And the idea behind the discussion is to open up communication between the parties and perhaps seek a solution that the parties can live with. The goal in a mediation is really for the mediator to explore with the two parties what we like to characterize as a win-win solution. So it's a little bit different than going to court with your dispute where someone's going to win and someone's going to lose. The idea behind mediation is to create a win-win, and for the most part, it works exceptionally well.
I like how you say the idea behind mediation is to create a win-win. That's a great way to describe what mediation can do for individuals that go through the process. So thank you for sharing that.
So, Tracy, thank you for that. And so, Jack, I'm going to transition into the controversial part, the part that around the world, and in particular in the United States, about this professionalization of mediation. Because as you mentioned, mediation is a superior mechanism for working on a number of types of disputes, as you mentioned, that is really not appropriate in the court, especially when we're dealing with ongoing relationships. Yet that there's this question about, in our field, about the professionalization of mediation. So let's get into that piece of it. And so what do you mean by the professionalization of mediation, and why does this even matter to the listener who might be in need of a mediator?
Well, with a mediator, thank you, Patty, great question. And with a mediator, you are sharing, if the mediation is going to work, you're going to be sharing your secrets, your innermost feelings, and perhaps, depending upon the type of dispute it is, things about your finances, things about your life situation. We have in mediation what we call confidentiality, which means anything you said during mediation is to be kept confidential. But unlike other professions, occupations that deal with the public, and other professions such as nursing, social work, doctors, lawyers, even to some extent teachers, we don't have any binding, enforceable ethics code that keeps those confidences or enforces the confidentiality of mediation. So although it's everyone's intent to form that circle of confidence, there's really no way to enforce it. Unique in that you consider the other formalized professions that deal with the public, that offer services to the public, that involve either legal concerns, health concerns. They're all bound by ethical codes. They are bound by, oftentimes there's licensure exams, there's other requirements for them, whereas mediators, technically under the law in almost every state, really have no such requirements.
So now someone might be listening who is either a mediator or even just someone who has, knows a little bit about mediation, and if they were to go online and type ethics code for mediators, they would probably find that there is a standard of ethics or a standard of conduct of behavior for mediators, let's say through the American Arbitration Association, the Association for Conflict Resolution, etc. So clear up the confusion that they might be having that says, well, we do have a standard of code. What is the distinction between what you're saying it's not binding and enforceable? So clarify that for those who are saying, wait, we do.
Well, another great question. Some would say that a rule without an enforcement mechanism is really no rule whatsoever. And you're right, Patty, that we do have, in fact, not just the ACR, ABA, AAA code that you referred to. There's over 30 different mediation codes governing various aspects of mediation in the country, and yet none of them are directly binding on any mediator. They remain somewhat aspirational in nature. So, yes, mediators see these codes. Mediators are aware, we hope, of these codes. But the reality of it is there's no enforcement mechanism for the codes. So, hypothetically, if, in fact, a lawyer you contacted breached some part of the State Bar Ethics Code, there would be potentially a remedy for you. You may not enjoy that remedy, maybe litigation, but there's still a remedy. If a mediator breaches an ethical code, because it's not binding and because it's not really enforceable, there's no remedy for the disputant. And that's what I mean about there's no binding ethical code.
Okay, thank you for clarifying that. That makes it very simple for the listener to understand. So let's break this down a little bit, because one of the things that you talked about is confidentiality. And so, Tracy, I'm going to go into this piece first and then turn it back over to you. So one of the things you mentioned is the confidentiality, that mediators are bound by confidentiality. Are they legally bound by confidentiality? So if they breached it, there's still no legal enforcement. So clarify that, because that's a big one that you brought up.
Well, if your listeners do take advantage of mediation, there's usually, almost invariably, a document circulated at the outset of the mediation that says that we all promise to keep whatever's said here confidential. But at the end of the day, unlike a contract that you might sign, this document has, while it has some aspirational effect during the mediation, it gets everybody hopefully living up to the same ideal of looking towards resolution. The reality of it is it's not a binding contract. There's no enforceability of it. So part of that is the evidentiary codes in every state in the country pretty much bar any communications made during mediation from any later court case, civil court case, which means, in effect, that even if a confidence were to be violated, since it's barred from being introduced into evidence, although you could bring a court case, you wouldn't have any evidence to use in the court case. So that's what makes it non-enforceable.
Wow, that's very, very interesting. So your listeners just tuning in, you are tuned into the Texas Conflict Coach Blog Talk radio program, and we're talking with Dr. Jack Goetz with the American Institute of Mediation, and he does a lot of work around certification and professionalization of mediation. He works with a number of nonprofits in this area, and especially with the Southern California Mediation Association. They have an ad hoc committee on voluntary mediator certification, and this is a very, very hotly debated topic, not only in the mediation field, but the reason we brought this up into the program, and this is where something, Jack, you feel very passionate about, is listeners need to know, consumers need to be aware of and prepared that if they're going to use mediation, they need to know certain things, because we're not regulated. We don't have binding enforceable ethics codes. So, Tracy, I'm going to turn it over to you to continue with this piece with Jack.
Okay. Thank you, Patty. Jack, you previously touched on with Patty the professionalization of mediation. So I would like to go ahead and switch gears and switch to, what do consumers need to be aware of and prepare for if they choose to use mediation, knowing the field is not regulated? What should they know and be aware of?
Well, there's really the three different areas, but let's just break them down. The three areas would be: they need to know something about confidentiality, they need to know something about mediator conduct and ethical code violations, and what they can do if something goes wrong during the mediation, where they can complain to. So those are the three things at least I would want to know, and what I'd pass on to your listeners, the kind of way I'd prepare myself as if I was a disputant in the mediation. So the first thing, what we said before about confidentiality, you just have to know going in that there's no binding, enforceable confidentiality provision. There's something you will sign at the mediation, and everybody means and intends it to have effect. But knowing that it's not binding and enforceable means that you have to develop a trust in the mediator and a trust in the process. And that's really, as far as the confidentiality goes, is your trust in the mediator and trust in the process. Later on, maybe we can discuss how you develop that, but that's the first and most important thing about confidentiality. Trust the mediator, trust the process. The ethical code violations, and what you should know about that all it means is that, again, you might want to look, and we'll talk a little bit more later in the program perhaps about this, you might want to look for mediators that come from a specific panel. Maybe they come from a court panel, or maybe they come from a private panel that makes some guarantees as to the mediation process. And that runs into my third point about a complaint process. Oftentimes, courts that have panels of mediators or panels in the community that are organized by a specific organization in the community will have some rules that govern the mediations that they conduct. Some of those rules apply to violations that might be perceived as ethics, or they might apply to how you would go about filing a complaint. Those are things I'd be aware of before I engage in the mediation process. It's something for your listeners to consider.
Thank you, Jack. I just wanted to clarify for the listeners, just in case they're not as well-versed in mediation as we are, can you speak to a mediation panel and just let us know exactly what a mediation panel consists of?
Okay. Well, there are many organizations throughout the country that organize panels of mediators and have specific qualifications for their panel. So if there's a community organization, for instance, in Texas or even in California, where that is organized to mediate disputes in the community, there may be some rules that govern that by the organization that's formed these mediators together. So hypothetically, the organization would say, our mediators all have X qualifications plus Y background, and these are the rules that govern our mediations. So there's some comfort in that someone has qualified the mediators for you, some third party. And again, you'd have to have trust in that process. Similarly, most courts in the country, not all, but most courts, do have a process by which cases that are brought into the court system, they have created mediation panels. They also, and panels would be, again, group of mediators that live under the court rules. So the court would qualify them on their background and education. The court would have a system of assigning the case to them. The court may even have their own local ethical code and a complaint process by which if something goes off during the mediation, you can check in with the court. So that's what I mean by a panel. Someone has put some thought into the organization of a group of mediators who have been qualified under certain rules and live under that rule book, and that gives some comfort to the consumer disputant.
Thank you, Jack. I appreciate you clearing that up for us. Patty, is there anything that you would like to add?
Yeah, so a couple of things. One is, for example, in Texas, and Tracy, you'll have an example because you actually work with a court-related program. For example, in Texas, and we call them the Dispute Resolution Centers, or the DRCs, and they're essentially a community-based mediation program, but they're funded through the courts so that people who file small claims, violations, landlord-tenant, small business disputes, it could even be child custody types of things that might come through the court, are regulated by court rules, as you were mentioning, Jack. And so that would be an example of a mediation panel, if you will. And they do have certain rules. You need to complete 40 hours of mediation training. You must observe so many mediations. You must co-mediate with so many people, or maybe their model is co-mediation. And so they're very, very well regulated in that sense. And they have to, upkeep with so many CEUs, continuing education, and ongoing training and observation and feedback. And so in that sense, that's what we would use here as an example. And Tracy, you work in Maryland with a court type of program that has a panel, right?
Yes, so we also have rules that we are also supposed to go by as well. There's specifically the 40-hour training. There's also the continuing education component. And there's also the Maryland Mediator Standard for Excellence as well that also provides training for mediators and continuing education so you can hone your skills.
Okay, so it sounds like, Jack, that, there's a lot of states that have these or not, but the thing about it is there's so many mediators, and I think this is the point that you're also making, and for listeners to understand that there are a lot of private mediators who are not connected to these programs or these panels where there's some sense of a boundary, if you will, or an area where they're creating these areas of accountability. There are many, many, many private mediators in all areas, whether they're workplace mediators, they're family divorce mediators, commercial mediators. There's mediators of all kinds that are not related to a mediation panel. And so, again, being aware, what you're saying, Jack, that if you're going to hire someone from that angle, what are they really bound to? So let's say that someone does, I guess the two follow-up questions is, what if they choose to hire a mediator who is not on a mediation panel? Where do they go then? Or maybe there is nowhere to go if they had a complaint or a problem with that professional mediator.
And Patty, you hit on the answer. For the most part, there probably is no place if they're not part of some panel or some system of mediators that's being organized. And again, I for your listeners, oftentimes, I think in your intro you said something about me organizing the first internet law school that was accredited, and that's all true. But some of us, we try to envision a better future for everybody. And when you think about the fact that, yes, courts do have mediations and mediator panels, but why should all of us have to file a dispute in court to be able to take advantage of that? In other words, wouldn't it be a better world for all of us if we know dispute resolution and mediation is a superior process in many cases? Wouldn't it be nice to have a way of being able to vet mediators, to analyze, to know there's some quality assurance with the mediators we can call privately without having to go through the courts, without having to go through a lawyer? That's the future that I live for. That's what drives me. And Tracy began this with, what drives my passion. This is what drives me, is a future where you could pick up the phone or look online, more likely in today's world, and get your mediator and know that there's some quality assurance behind that. That situation does not exist for the most part unless, as you mentioned, you file a legal dispute in the courts and go through that hassle. Then you get access to some of these.
Well, and I love what you're saying in the sense that, we shouldn't have to put the public through, going through the court in order to access this type of a panel. And, of course, there are other panels like there's JAMS. Now if I have to say what the acronym stands for, it eludes me, but you might be able to do that. But certainly the AAA, there's a number of those types of panels that are not directly related to the court that people can access. But I think the point is that, and I guess the question, because you're doing so much research, is why then is this so hotly debated? It seems like it makes honest sense to professionalize and do what all these other professions are doing. So why is it so debated? Why is there so much resistance, if that's what I'm sensing from you, of moving in that direction?
I think we've always, when you're trying to change a status quo, there is going to be resistance. And so for quite some time now, the system has existed the way it is. And so whenever you bring in a change, someone's going to say, well, if it ain't broke, don't fix it, kind of approach. And I guess those of us who envision this new world where we can vet mediators on our own and understand there's some quality assurance behind that, think that any time you offer a service to the public that could affect substantial legal rights or health care, that you owe it to the public to do the proper training and take the proper tests and be qualified, that should go with offering a service to the public. So I think, obviously, when you look at the mediator community, I don't think there's quite as much resistance as people suspect. I do think that the mediators who have done quite well in the current status quo are very vociferous about their objection to any change in that status quo. But we're finding, as we present this throughout California, that we have a lot of people nodding their heads and saying it's about time We were with a group in San Diego yesterday where someone came up to me out of the audience. I've been a mediator for 30 years. I've been waiting for the day when someone would do this. It's beyond time to do this. So I think there's less resistance, but I do think, like anything, the resistance is the resistance to changing the status quo, and it's very vociferous.
So it sounds like with the work that you're doing in California, of course, you're on this Voluntary Mediator Certification ad hoc committee, and so what's the path then you are taking to try to move us in this direction, or at least in California? You haven't taken over the world yet, but you are moving in that direction. So what specifically are you trying to put in place then that you want the listener and the consumer to know?
Well, good question, Patty. And again, we didn't have to start this in California on our own. We had the benefit of tremendous groups such as ACR and ABA having task force reports where they studied this issue for many years. And so we have a lot of research to work with. I think what we're trying to do is look at it like any other occupation that offers services to the public. So what qualifies a nurse to be able to say he or she's a registered nurse? What qualifies a social worker to say they're a licensed social worker? What's the thing that elevates a field from just an occupation to a more formalized group of, might say, formalized profession? And really there's some distinctive characteristics in our research about what elevates a group from an occupation to a respected profession. One of those happens to be background education. And you and I know, and your audience, I'm sure, as well knows, that some of the professions that we've talked about put in thousands of hours of education. And we're talking here that mediators can do it on 40 hours, and they're off and running in Texas. So something needs to be done about that, and we're trying to go through the state and get some sense on what we can do to raise the bar on education and mediator training that could be universally agreed upon as, that's got to be a new baseline. So there's education and training that needs to be done. There's, as I mentioned before, an agreement to be bound by an ethical code. And again, as we discussed, the court panels are often agreeing to be bound by an ethical code, but oftentimes private mediators have no such agreement. They'll hand you a confidentiality statement, but there's no binding ethical code that they've agreed to. So we're working on that, and obviously, as you mentioned, the ABA-ACR code is one that's widely utilized and could be used as a binding ethics code. And then, finally, there's got to be some sort of quality assurance, grievance process that people can agree to. The confidentiality during a mediation is extremely important, but courts have developed a way of handling complaints over the years, if there are complaints. And again, I don't want to make it sound like there's been tons of complaints, but there are some, just like with every profession. There are some. And so the courts have a way of lifting the hood slightly on the confidentiality for the purposes of investigating the complaint, and we're investigating whether that could be implemented more on a statewide and perhaps nationwide, eventually, system. So those are some of the key components we look at when we're trying to elevate this field to a higher status and something that gives the public some quality assurance that they can call a mediator without going through the court system.
Okay, so ultimately that is, one of the goals, but in a way that protects the public, because I know as a licensed clinical social worker, one of the things is where, the licensing board and all of that is about protecting the consumer, of licensed clinical social workers, and there's all these levels of qualification and, testing requirements, and it's extensive, and so their job is to protect the consumer, to make sure that there is those remedies and those things that are available to the consumer of these services. And so, that's what I'm hearing you say, and that they have the freedom to choose, mediators of their choosing in the future, that they know that they have an option if there becomes a problem. And so that would be, very interesting. And I know it's going to be a while. This is not going to happen overnight. But I'm very glad that you brought out these elements, because we've talked about mediation many, many times on this show about what it is and how do you prepare for it, how do you select a mediator, but nothing to this extent to say, hey, we want to raise a red flag, to say, be really careful about some of these things and really understand that. So, Tracy, what other things do you want to add before we start our closing process?
I think you touched on everything, Patty.
Okay.
Thank you.
So I'll turn it over to you, Tracy. We'll go to our closing process then.
Okay. So, Jack, what we usually do is we touched on a lot of information for our listeners, and we like to leave them with a call of action, an assignment for the week, so to speak. What would you like for the guests to go out and do after listening to this program?
Well, I think there's a couple things they could do, and just to become better informed as a consumer. And one of the things is just to anticipate what would happen if you get into conflict. Now, a lot of us are reluctant to do that. I mean, what's the likelihood of getting into conflict? And yet, all of us know we have conflict going on in our lives all the time. You have neighbors who have noise issues and you can't get to sleep, or a dog barking issue, or you have a tree that hangs over your, two fences and you get all the debris and your neighbor gets the tree. There are a million things that come up, and I would suggest the call to action would be this. Try to think about your life and what could potentially develop into a conflict. Maybe it hasn't yet, but it could potentially develop into a conflict. And just take a look around on the Internet. You still use a phone book. You can use that too, but the Internet's probably more efficient. But take a look at what community providers and mediation providers are in the community, and if there are panels that are available to you locally. Take a look at your court. Usually the place to take a look at your local court is wherever they have the small claims section on their website. They'll talk about what kind of mediation panels, just so you know if something develops where you can quickly go to a place that you can potentially trust, particularly if it's a panel, organized panel. And that's what I would hope every listener would do, is just take a few minutes and anticipate a conflict and see where you might go with that conflict.
That's great. So the listeners, their call to action is to reflect on any aspects of their lives where they may have conflict, and then go out and see what resources that are out there for them. That's
and Tracy, I'm sorry, I'll just add one quick thing, and that's oftentimes the Better Business Bureau may, in many communities, organizes mediation units, or the city attorney's office may have mediation units. So you may just want to take a look at some of those resources.
Thank you, Jack. Is there any contact information that you would also like to leave with the guests, or any training or services?
Well, I don't. I have a few contact places that I think would be of help to them. One is I do a lot of work with the American Institute of Mediation, and they have a website, www.americaninstituteofmediation.com, so all one word, americaninstituteofmediation.com. And they do a lot of trainings in the community, trainings for mediators, for those of your listeners who may say, hey, this is something I would like to get involved in. The American Institute of Mediation does it at a very high level, and the President Lee J. Berman is often in Texas. In fact, he's doing an upcoming training through SMU, often in Texas. So it would be a resource for your listeners. Also, our work, if the listeners want to follow our work, we're at scmediation.org. So www.scmediation.org, and through that you would find the work the Southern California Mediation Association is doing through our committee on this very issue. And if your listeners want, they can keep posted on it because it is evolving, and we change what's on the website every month or two to reflect the new developments.
Thank you. And lastly, is there a final message that you would like to leave with the listeners tonight?
Well, now that I've been raising all the red flags, I would still say that despite the challenges I've outlined, mediation is a superior form of conflict resolution, and none of what I said should detract from the great work done by thousands of mediators across the country annually. And I think your listeners should perhaps focus on the fact that all I'm doing within our field is trying to call for a greater level of accountability. So even though mediation has done well, has had success, and has worked well for a lot of people, all I'm saying is we need to raise our game a little bit. And I think that's all going to be a good result for your listeners.
Thank you, Jack. It has been a pleasure having you on this evening, and we really appreciate it. It's been very informative for the listeners.
Thank you,
yes,
Tracy.
thank you very much.
Thank you both, and I very much appreciate the opportunity.
Well, thank you for educating our audience with that message, because I think it's really important for them to understand the red flags and also your final message, so thank you.
Bye-bye.
Thank you. Thanks, everyone.
Thank you for listening to the Texas Conflict Coach. We hope you've enjoyed the program. You can find over 300 podcasts archived to listen at your own convenience at texasconflictcoach.com or download the podcast at iTunes or Stitcher Radio. To learn about upcoming radio programs and resources, sign up for our monthly e-newsletter.